Minimum energy efficiency standards. Another little piece of legislation that crept in on the 1st of April 2020. Now, I say crept in, guys. Hopefully you would have been aware of this, because actually this legislation came out 3 years ago. I think initially 2018 was the first change, 2019 the second, and retrospective, we were looking at 2020. So 1st of April 2020, every single property that is rented out in the private rented sector retrospectively, so whether you've got tenants in there or whether you haven't, has to carry a minimum E rating. If it doesn't carry a minimum E rating, you are breaking the law. Exemptions are available, but they are very difficult to obtain now. They are much less easier to obtain. There's much more criteria surrounding exemptions. It's just become a little bit harder to obtain an exemption where one is required. One of the things I'd say to you here is listed buildings are not always exempt. Listed buildings potentially are exempt, but you need to check with the council what type of listed building it is, and then with the EPC assessors whether or not that particular property would be exempt as a natural cause. One of the things to bear in mind here is, in fact, a question again I had the other day. As a bedsit, as a HMO, there's tentatively argument that those type of properties don't require an energy performance certificate under the regulations. And I say tentatively because I disagree really. But actually, forget the EPC regulations for one moment, and let's just talk about the Deregulation Act 2015, a piece of legislation that's been in force now for 5 years, 1st of October 2018. Sorry, 15, 18 was the changes, 5 years, which quite simply says that in order to serve a Section 21 notice, you have to, as a landlord, be able to provide evidence that you have provided to your tenant a compliant energy performance certificate, a gas certificate, a how to rent guide with the current version, all of the tenancy deposit information, and a license where applicable. If you have missed one of those documentation, you cannot serve Section 21. So forget the EPC regulations and the MEs. Do you want to get to court under a Section 21, potentially a Section 8, and the judge throw it out because you do not have evidence that you served an EPC, because you didn't have one, because you were arguing that the other piece of legislation said you didn't need one? It just isn't worth it, guys, honestly, for the sake of, I think, 75 quid for 10 years, average £7.50 a month, a year. I mean, it's just not worth it. So please ensure that you comply. Now, for many of our clients, what happened was a year and 2 years ago, there was actually a rule that said if a landlord had to spend a single penny on improving the property, he could apply for what's called a no-cost exemption. So basically that means everybody applied for no-cost exemptions because they obviously have to spend a penny to improve the efficiency of their property. So many landlords, a lot of ours included, applied for no-cost exemptions. Then we got the big bombshell in about January, I can't remember when, but just prior to the end of March this year, that actually your no-cost exemptions don't no longer last for 5 years, which is what we were first told. They actually expire on the 31st of March 2020, and you need an E-rated energy performance certificate, or you need to apply for one of the other exemptions if applicable. Now, the other exemptions are as shown on the screen. Please excuse me, I have to read these because I want to get them right. So the first exemption is an all relevant improvements exemption. What that means is that if it would cost more than £3,500, including VAT, to improve your property to an E, and you have carried out all of the recommended measures that can be installed within that amount, then you can register an exemption, because it would have cost you more. You've spent the amount that you're supposed to, and it still hasn't took it above an E, so you now apply for an exemption. Unfortunately, Mr. Landlord, you still have to spend £3,500 before you can do so. This is why I've been banging on about this for years, and those that come to my seminars, this is why I've been banging on about it for years, because we needed to get ready. Now, high cost exemption. You can register this exemption if no improvement can be made because the cost of even installing the cheapest of measures would exceed 3.5 grand, including VAT. So you can register a high cost exemption. Now, I'm not a professional against the exemptions. This is just data that I've captured. So please, if you want to look at it further, please do give me a shout. Exemptions will last 5 years, but that's what they told us last time, but just bear that in mind. They will last 5 years, and then you will have to try and improve the EPC again. Good news is if you have made any energy efficiency improvements to your property since the 1st of October 2017, you can include whatever the cost of those improvements were within your £3,500 cap. So if you've already spent £3,500 on improving your property, you've already met the cap, and therefore you may qualify for one of the exemptions if it's still above an A.